privacy. Information which you normally would not share about your health, about other things, would be related to invasion of privacy. But the other things will not be covered under this. And therefore, as far as the public interest part is concerned that Shekhar mentioned, out of the 10 exemption clauses, 3 exemption clauses mention private public interest. This, I think, has been a drafting error because section 8.2 gives the talk of public interest being an override to all the 10 exemption clauses. So therefore, my personal perception is we need not bother about the public interest being mentioned in 3 of the 10 exemption clauses. Section 8.2 anyway talks of public interest override. When there is a public interest override, then of course you will ask the appellant to justify the public interest, in which case the question of purpose will come in. But otherwise, reading anything specific in this public interest clause, which is in this subsection, is relevant because it's also there in 2 other subsections. And since 8.2 provides a complete override to section 8.1 in terms of public interest, whenever an exemption is claimed, the appellant can justify and say there is a larger public interest, which he will have to justify. There, of course, he'll have to disclose the purpose of asking for this information.
Interesting, Shailesh, actually, that you are interpreting person in terms of the individual human person. That's one very important thing. Because I think the General Clauses Act will say person will include also legal entities and so on. So that's a very important development to make in the law as far as this is concerned. To depart from general law and say person means the individual person. The corporation and so on will not have any. The second is, if there's a public interest justification for 2J, then the answer to somebody's question here a little while ago, can you ask for information relating to the spouse of an employee? And then you say, all right, the justification for that is, I believe that money illegally earned is being put into her account or put into her son's account and so on. Then you might justify even asking for the spouse's details or the son's details and so on and so forth. Personal information, but this is my justification. Then if you take the defense of privacy, privacy would mean legal privacy. That is to say, all your private actions
and children. Having said that, I cannot see any argument which says that those who want to be public servants must declare, but those who are public servants need not. I mean, I find the argument completely fallacious. It's only because the courts, when they suddenly realize that they are public servants, have started taking a different viewpoint.
Sir, the conduct rules, NVCA's filing of annual returns, property returns, in respect of the employee only, and not about their spouses or major sons and daughters. So the public authority may not be having the details of the property of the wife of a particular employee or the son and daughter of a particular employee. In that situation, I don't think the PIO will be able to furnish the details of the property of wife or son and daughter of the employee. Because it's not obligatory for any employee to submit the details of the property of his wife or his major son and daughter.
So that's fair enough. I mean, if you don't have that information, there is no problem. Can I just flag another issue here with the same thing?
Sir, can you quote me the relevant portion? Because service conduct rule says family assets. It has clearly says family assets, not personal assets.
Nowhere it is mentioned.
I will be rather pleased, sir, if you can quote the relevant portion, or if you can mail me the relevant portion.
It does not say family assets. You go and read it.
Yes, it is family assets, sir.
Okay, we'll sort this out at lunch. I just wanted to flag one very interesting case which the Information Commissioner from Mizoram brought to my notice, and of course we all know about it, and that is the Arvind Kejriwal case, where he had applied for information relating to the promotion of officers to joint secretaries, additional secretaries and secretaries of the Government of India, and on what basis were these promotions, etc. I mean, the CIC held that this should be given to him, and in fact he started the process of accessing this information. But meantime the DOPT went to the High Court, and the High Court said no, this should not be given. Now this is a very interesting case, because on the face of it, there seems to be a lot of public interest in trying to find out Who are the people who get promoted? On what basis? Who are the people who get posted to? I mean, how did this gentleman get posted as director in the Home Ministry, in the Internal Security Division, which is the most sensitive post in the Home Ministry? So we want to know. We also want to know what is wrong with the system. Was it collusion? Was it incompetence? And you cannot know this unless you know this. But the High Court held this. So what I'm trying to say is that therefore this whole privacy thing, I think, has become the sort of bugbear where one is simply saying, no, but this is something that the public has no interest in. I think the point that we need to make is that anything that is a matter of good governance is of public interest. That is the preamble of the thing, and therefore if it helps us to make sure governance is better.
I agree with Mr. Singh. Just imagine a situation in a terrorist affected area of the state and of the country. If somebody goes and asks, and we hear that in certain northeastern states, government officers have to pay regular ransom to certain groups. Supposing somebody goes and says that please give me the immutable property return copies of the property returns of the X set of officers. Or a thief goes and says that he would like to have the details of what property you have or income tax return you have so that he can plan adequately to access you when you are not very careful. So I think that there is some merit in the decision of the CIC that certain information, like about your body, the property and the body are the property of a person and his body are similar. So therefore, the property of an individual, unless there is a CBI inquiry about him, about his disproportionate assets, in which case it is in public interest that this matter should be disclosed. That is the view which you have taken.
No, on this, the example which I just took in the beginning by way of introductory remarks regarding the whole body scan, total body scan, and the Harry Potters in this particular comes here. So this is the kind of borderline we learn to draw. So it's purely subjective. It cannot be an objective kind of decision as far as this is concerned. What is personal? My perception may be totally different from what Mr. Jacob Singh says or will say. So